Hello, this is Dr. Dennis Saccuzzo. I'm here with Professor Andrew Poplin, and today we're looking at evidence. Professor Poplin, can you run through this, please?
Yeah, so this is the historical testing of California evidence since the very first time it was introduced on the exam. They first said it was fair game in 2007, and then you see down there in February 2009 was the first time they showed it to us. It was criminal. And since then, it's come every few years or so, sometimes back to back, but it's gone criminal, civil, criminal. There's a weird crossover. It was a civil remedies fact pattern, then criminal again, and then a couple of civil in a row.
But I'd definitely be prepared for an evidence question. I mean, the basic approach is you've got to learn the Fed first. Once you have the Fed down, then you study the distinctions. So let's talk about a general approach for both federal evidence and California evidence. All right, so we say California evidence up there. How do you know it's California evidence?
Well, usually it'll be pretty explicit because there will be some sort of a call that mentions assume all proper objections were made or something about admissibility or testimony, and then the real giveaway for California evidence will say answer according to California law at the bottom.
Okay, and if it's silent?
If it's silent, I haven't seen one that's silent in a while. If it is, then you'll have to look at the facts. Are we in a California Superior Court? Are we in a federal district court? That could be telling. But usually it will say answer according to California law, or in the last few years I've even said answer according to federal rules of evidence. So they should give you, pretty clear instruction.
Okay, and they may not because they're always trying to throw curveballs, and if they don't, as indicated, look at the facts. And what's the first, if it's answer according to California evidence, what's the first thing?
So the very first thing, if you've got a full-blown California evidence fact pattern, is to head note and address Proposition 8. And this will end up only applying in criminal cases, but that's the very first thing that you want to address.
Okay, and a question, should you discuss Prop 8 even if it's not a criminal case?
I think it's good practice because you can still deal with this issue in maybe 2 or 3 sentences. You can get out there what Prop 8 is in general broad strokes, and that only applies in criminal cases. And then you can just say, here, this is a car accident case. So it's a civil case. Prop 8 won't apply. Now you've covered your bases and you can move on.
Perfect, and you've used your facts. And of course, if it is a criminal, then you talk about Prop 8 and you say, here there was a homicide, so it's a criminal case and Prop 8 will apply. So either way, when you put down a rule of law, always discuss some facts. If you just put down a rule of law, and the precise instructions from the California Bar tell you, if you just put down rules of law, you don't get any points. So you have to always do some analysis. All right, then after you discuss Prop 8, if it's California, if it's not California, then if it's federal, we're going to start with the possibility of form objections. In either case, if it's a transcript style, we want to look at the form objections. And one thing that's good is California and the federal will use the same form objection. So what would be an example of some form objections they've used?
One that they like a lot is non-responsive. So if they're asked a yes-no question, even though this might be different in real practice, but they'll be asked a yes-no question and the witness will say yes and then continue to embellish and basically exceed the scope of what was asked, and they want you to mention non-responsive.
And then once you say non-responsive, you should always add motion to strike. And sometimes the question even says, when should there be a motion to strike? And of course, the big one is if the answer is non-responsive. So you got to look for that. Calls for a narrative is another one that I've seen quite a bit. Assuming facts not in evidence comes up sometimes as well. Use your facts again. If it's assuming facts not in evidence, tell them what facts are being assumed. So basically, you always want to use your facts. One of the biggest mistakes I see in evidence answers is it's done by just discussing law without discussing facts. All right, so you begin with the possibility of form objections. You ask yourself, is there a form objection? Then the very next thing you do, or sometimes it's the first thing in your book, is to discuss logical relevance. And what's the difference between California and the federal?
it's easy. We've highlighted it for you here. Is whereas in the federal, it just has to be a fact of consequence, makes that a fact of consequence more or less likely. In California, it has to be a disputed fact of consequence.
Now, one of the must knows, the must learn, and you'll get it. So when we're in phase 3, the very last phase, for those of you that are in our courses, or even anybody out there, you should follow our procedure, our phased approach. It's definitely the most effective one out there. So in your last studying, you should try to recall the rule for logical relevance. You should know that rule and you should be able to write it down. Now that said, once you write it down once, never write it down again, because if you made a mistake, and do not cut and paste, because if you made a mistake, you'll cut and paste the error again and again and again. It'll grate on the grader's nerves. And if you write it down more than once, you're wasting your time. So just say logical relevance defined above, and then quickly, after you've done the first one with your rule and your analysis, subsequent logical relevance analyses, just jump in and explain what the logical relevance is.
And I've gotten questions before with regards to this distinction here is, okay, so in California it has to be a disputed fact. What would be a situation where that would be teased out? And the biggest thing that we've told people to look out for is where there's been a stipulation, where the parties agree to something, now it's no longer in dispute, and therefore if someone was introducing evidence that went to a stipulated fact, you would mention, in California at least, it's no longer in dispute, it's not relevant.
Yeah, sometimes they'll say one side, the defense stipulates to liability. And that happens a lot, actually. It saves a lot of court time where liability is clear. You get a stipulation to liability. Then you can't introduce facts that go to liability. All right, now, legal relevance must also be in your book, and especially if it's a California hypothetical, because in the case law, this 352, especially in criminal cases, this 352 is always used. So let's just say that the federal rules wouldn't allow it, but Proposition 8 allows it. And then, okay, Proposition 8 would let it in, and then the case law goes, but 352, legal relevance could keep it out. So you must discuss legal relevance. And how's legal relevance different federal to California?
I would tell you, for all intents and purposes, in writing down on a bar exam, if you have FRE 403 memorized, that's the federal rule for when probative value of evidence is substantially outweighed by prejudice and undue prejudice, actually, or delay. It's the exact same in California. So if you know the federal rule, you can just say CEC 352, and this is one of the few rules that we say know the number, right? You should know what 403 is in the federal rules, and you should use the number 352.
When you do your legal relevance analysis, you should discuss what the probative value is, and you should discuss what the prejudice is, and you should balance those two. And that's what they want you to do. I mean, a lot of people say, well, they'll state the rule, but they won't do the proper analysis. So it's all about weighing the probative value versus the danger of unfair prejudice or the danger of prejudice. All right, next, character evidence. You've got to go in looking for it. Now, with one minor exception that we're going to talk about, California and the federal, pretty much the same, right?
Yes.
Okay, so now you look for it. Look for it. Now, one way you look for it is where someone wants to talk about a prior act of the defendant or a prior act even of a witness. Say, no prior acts. No prior acts. That's character conformity evidence. So if you say, well, he did that before, so it's more likely he did that now, that's what we call character conformity evidence. The general rule is character conformity evidence is inadmissible. So we can't introduce character to show that the defendant acted in conformity therewith. Now, second way that they have character evidence is we have a witness that's going to testify as to a trait of the defendant. The defendant is a bully. The defendant is a liar. Okay, well, except if we're trying to do impeachment, right? Then a liar would be relevant, wouldn't it?
Yeah, so typically for the type of character evidence Dr. Saccuzzo is talking about, you're going to be dealing with maybe violence or peacefulness, those type of opposing traits.
And then what's the exception that's different in California?
So in California, and they've tested this, so this is really important to know. They haven't come back to it a second time yet, but I wouldn't be surprised if they do. But you need to know that when we're dealing with past character evidence of a victim, there's an important distinction, and you see it there on the slide. The defense is allowed to basically disparage the victim through the use of reputation and opinion testimony, and that might take the form of something like the victim is really violent. In other words, trying to prove up maybe a self-defense claim that the victim was the initial aggressor. The defense can do that through reputation and opinion testimony, and usually in the federal rule, that's where it ends. There's no specific instances, as Dr. Saccuzzo already mentioned. But in California, specific instances are specifically allowed to disparage the victim. And you can look at a fact pattern that we have highlighted there, July 2010 question 3, fleshes that out.
Now, this issue of bolstering has not been tested, and I think it will be tested at some point. So basically, you can't bolster a witness, say this is a good witness, this is an honest witness, until that witness's credibility has been attacked. So that's called bolstering. So you can't say this upcoming will be the most honest witness you're ever going to see. Can't do that. If that witness's credibility is attacked, then we can bring in other witnesses to say, no, that's a credible witness. However, in California, because of Proposition 8, there's a case on point where the police had an informant. And of course, the better the informant, the more likely we're going to have probable cause. And what the police said is, well, now you're going to be hearing from a really reliable informant. So that was bolstering. It was also character conformity. And so there was an objection, and the California courts let it in. And 352 did not keep it out. So bolstering is allowed in California.
Now, of course, you would have them do a 352 analysis depending on their own facts that you have.
Absolutely. So the bolstering, you say, yeah, generally in California comes in subject to a 352 analysis. And then you discuss the danger of unfair prejudice. How much prejudice do we have here in this bolstering? Now, hearsay is always tested. And sometimes it's 2 or 3 instances of hearsay. Sometimes it's 90% of the hypotheticals hearsay. And your general approach is step 1, show it's hearsay. Out of court statement, offered for its truth. So show where was the statement made. It was out of court. Well, then where was it? And is it being offered for its truth? And this is it being offered for its truth is critical. You have to ask yourself, why are they trying to get this thing in? And if it's not being offered for its truth, then it's not going to be hearsay. So you have to establish offered for its truth. If it's out of court, offered for its truth, then you want to try to find 2 colorable ways out of the hearsay rule. They don't have to work, but they have to be, at least in the ballpark. And you have to analyze them, and you could say, well, this one would work when this one wouldn't. But try for 2. Now, any further comments on hearsay?
Well, the only thing that I would add, maybe a corollary to that, is you want to try for 2. I've seen in more recent fact patterns, this isn't, for the older ones, but more recently I've seen, so where there's a dearth of issues, where hearsay is really the only main issue in the fact pattern, I've seen some selected answers came back that the bar, of course, is holding out as sort of exemplary, where they're looking for even 4 different ways around. So you kind of have to obviously look at your fact pattern. If you're going to run short on time, go for the jugular, right? Use one and make sure you finish the essay, but there will be some where you're looking at it and saying, gosh, I don't see a lot of issues other than hearsay. Well, then you're going to be doing a lot of, can it get in for this purpose? Can it come in for this purpose? And trying all sorts of different ways around the rule.
Yeah, in reading essays that have come back from the bar, of course, we get the whole range. Just because they come back doesn't mean they failed every essay. And I've seen people put 4 down.
Yeah.
And I see those get pretty high scores. They like to see that. And by the way, they like to downgrade heavily where you don't even try to get out of the hearsay rule. They will downgrade you heavily if you do that.
And you'll see we've listed a couple of fact patterns for you that, in looking at the past California evidence hypotheticals, if I was getting ready to take the next bar exam and getting ready for evidence, I would know all of the different hearsay ways around the rule that you see in July 2009 question 3 and July 2012 question 2. The 2009 one is a civil case, the 2012 one is a criminal case, and these combined, I think, cover 90%, if not more, of the different hearsay issues that the examiners like to raise.
And then privilege, when they first started testing, the early ones, they're all about privilege. You should know those privileges. They've tested it repeatedly and in cycles. All right, now, there are two marital privileges. There's the federal Trammell case, the federal privilege, and there's the common law privilege. And what you're going to have to do is get the elements of each one. I'm not going over those elements now because of timing. They're in our outlines. They're in every outline. You need to know the privileges by element, and you need to discuss both of them whenever you have this marital privilege issue. That's very important.
And there are distinctions between the federal privileges, especially with regards to the marital aspect, and California. And obviously that's why the examiners like to test that, and that's why we've highlighted that here for you.
So the federal or Trammell privilege, what do they usually call the common law privilege? Any special names?
So at least in California, I know the two ones that they should know, and I think there's the federal counterparts, is you have a spousal testimonial privilege and then the confidential marital communications privilege.
Okay, the spousal testimonial is the Trammell case. That's the so-called federal privilege. And basically, that's where they used to say, if you want to keep her quiet, this is old stuff, really old stuff. You want to keep her quiet, marry her. But it's not. It doesn't work that way anymore. If you go over that privilege, you'll see. Okay, just a few quick questions for Professor Poplin. Any advice for anyone studying?
One thing you have to realize about California evidence fact patterns is that they are bears. There are so many issues in these, and if you gave each issue the same amount of detail that you gave in, say, a tort or a property or contracts essay, there's absolutely no way you're going to finish in 1 hour. So one illustration that I would always give is picture the way that you skip a rock across the lake. If you throw the rock too much into the water, it's going to sink. You just want to skip across the top, get the main issues, and cover what you need to, and move on. It's about covering a broad range of issues as opposed to picking just a couple of issues and going really in depth. So I would say skip across the fact pattern, get through as many of the issues as you can.
Yeah, keep it rolling. Keep it rolling. Just keep moving. You've got 1 hour. And you know what? I don't care if this is your best subject and you're going to say, well, I'm going to blow the top off of it. No, don't do that. Basically, each essay gets an hour and no more. It's very, very important. All right, Professor Poplin, what about hearsay within hearsay? How do people spot that?
Practice. You have to spend time practicing it. And I can tell you, you can look at a July 2010, I believe it's question 3. We don't have it here on this slide, but it has an issue of double hearsay, and this has become increasingly one of the bar examiners' favorite ones, and I think it's because people have problems spotting it, and so they continue to roll it out. But the classic scenario is it's going to be either someone's trying to introduce in a record, and in that record there's a statement. Of course, the record itself is one layer of hearsay, and then the statement contained in the record is another layer. There's double hearsay. And then the other example you'll see is somebody's on the stand and being asked what someone else told them, what someone else told them. So there's 2 layers. Somebody told someone else, and someone else told the person who's on the stand. And you can see that latter version in July 2010, question 3.
Yeah, so you get something like Officer Oliver will testify that he said, she said. So basically you get your 2 levels there. So I'll just give you an example that actually came up on a criminal procedure mixed with evidence, where the officer illegally goes, says open up, and he doesn't have probable cause, and he cuffs a woman, and he says, I know you did it, and she said, I didn't do it. Sally said she did it. So that's, hearsay within hearsay. We got the first person who said it. I didn't do it. Sally said she did it. And then Officer Oliver wants to testify that the first witness said that Sally said she did it. That's hearsay within hearsay. Okay, finally, it says, answer according to California evidence. Should you discuss the federal distinctions?
Generally, no. If it says answer according to California law, you've got enough on your plate to worry about with that I would just answer according to California law. If, as you were writing it, and you had, by some miracle, a little extra time, and you came across one big major distinction where this was going to be outcome change in federal court, maybe mention it briefly. But again, if it says answer according to California, answer according to California. If it says answer according to FRE, answer according to FRE.
Just one thing. California does not have exemptions. So don't say, well, yeah, exemptions, your prior statements and your admissions. California does not have exemptions, but we do have comparable exceptions.
And we've actually seen selected answers do that exact same, so I don't know if we want to call it a trick, but they clearly put down what we know is the federal rule, and they just preface it with under California law, comma, and it's just the federal rule. So when you're in a jam, definitely good advice.
Yeah, don't waste a lot of time, contemplating or hesitating. You must keep it moving. Now, if you're not in our courses but want to participate in the simulation, we invite you to, and you'll have two options to do so. One is the score your own option. And the second would be to actually get our grading, which I think once you see our grading, you're going to say, wow. Because everybody who sees our grading, it's completely unique. You're not going to see anything else like it. One of the reasons is we know the law thoroughly, and we know what the examiners want. So we're going to be able to give you an accurate grade. We're not going to just say, gee, you should have broke this down into 2 sentences here. Basically, the bar examiners are told, as long as your grammar doesn't interfere with your answer, they have to just ignore your grammar. They have to ignore your spelling. So those little details are irrelevant. We grade you on the relevant aspects of your answer. Now, both of our options, if you choose either one of these, they're both going to include the simulation test packet. They're both going to include our debriefs on the essays and the PT, and they're both going to include our models.
As well as it's going to include some coaching from you, right?
Yeah, and some coaching from me. And I think coming up is going to be coaching about psychological factors, which I think a lot of people like. I'm nervous. I'm stressed. How do I cope with stress? My hardest part is dealing with the stress. And then finally, if you don't have power law, get it.